stop there so that my learned friend will continue.
Thank you. My notes, I will take it up from there, and I will dive right into the constitutional questions. The application before you for challenging the panelment of this bench addresses itself a lot to the powers of the Chief Justice under Article 161, (2) A and B, that establishes the office of the Chief Justice as head of the division and of the Deputy Chief Justice as the deputy head of the division, and conversely, to Articles 163, 1B, that again provides that the Deputy Chief Justice shall deputize the Chief Justice and be the Vice President of the Supreme Court. My Lords and Your Ladyship, it is now beyond our adventure, and again quoting from the CTS, that while Council submitted that there may be instances of delegation, they ignored, my Lords and Your Ladyship, that the law expressly provides instances or gives direction as to when the Deputy Chief Justice shall exercise the powers of the Chief Justice. And my Lords, this is expressly set out at Section 5, subsection 2A of the Judicial Service Act, Cap 185B of the Laws of Kenya. The Judicial Service Act expressly provides, my Lord, that the Chief Justice can deputize, or the Deputy Chief Justice will exercise the powers of the Chief Justice in the absence of the Chief Justice. And also the CTS and my friend Professor Gilbert referred to this. There are only two professors senior counsels here, so it must be correct. And Lord, in the CTS, it is clear that the Chief Justice communicated to the Deputy Chief Justice that should be a way to Geneva, Switzerland, and Milan, Italy, between the 12th of October 2024 and 24th of October 2024. That is not, it's in the banner, it's on record. It's on record. Senior counsel and my pupil master coordinated.
To keep your voice calm. Keep your voice calm. There's no need to shout. I was asking the court whether this material is part of the contract.
It is.
Or whether it is.
That's what I was asking. You taught me to submit.
And politely.
You taught me to submit clearly, and I'm polite. Yes, I was a student. My Lords and Your Ladyship, it is
It
therefore
is important that in my address to the court, I indicated that the respondents in that application did not file any replying affidavits, through which this material could then be introduced before you.
My Lord, it is part of the record. The record.
The material which is in the court portal is part of court record.
Your Lordship,
If it is not on the portal, it's okay. If the material is in court portal, it's part of the court record.
Your Lordship, there's
Mr. Degwa,
Just for good order, my house, let me make progress. Then we know, because we access the portal through particular case numbers, in which case file is this material available, then we can just log in and get to it.
my Lord, it is not in my place. We start educating, demonstrating my friends what files to do. Because this is the portal. I would have had no other way of accessing.
Professor, can you just give us a reference
Yes,
for purposes of clarity?
yes, my Lord, 05, we have 3 cases that are consolidated. We have accessed the portal in E015 of 2024, a transmission from Wanyama, and E014 as consolidated. We have this material and they're aware of it, we have even gone further, my lord, and served or passed on the communication to my land. It is in the public domain, my lord. We could not have secured this communication anywhere else.
Sorry, do you mean to say that what you're holding is filed on CTS?
It is,
Does it have a date and
yes.
time?
It is in the, like, what I have here is copy from the CTS, the reference of the Chief Justice Office.
Are you able to tell me?
We accessed, we only accessed it from the portal.
We are possibly simple.
Yes.
All right, first straightforward. There's an internal memo we've just been given here. My colleagues are saying it's on the portal. If we knew the case number which it was, we would have verified it. The other option would have been for my colleagues who are working a particular application this afternoon, have they had an affidavit running this document? Truth of the matter is that documents in the CTS have a timestamp, as my lady points out. The document we are having here does not have a similar timestamp. We're just saying, show us where it is so that we authenticate, then we make progress. It doesn't make sense to demean the rest of us when you're asked to authenticate. You do precisely that, you authenticate.
But Lord, I can confirm that it is even the physical file. This document, the physical file. So that my land and friends do not have it, or that they are shocked that the Chief Justice is not in the country, should be a point for response. They can respond and say, we saw the Chief Justice around. That's a possible development. My Lord, if I may raise into my time, they will have time to respond. Yes, the judicial report. I can proceed.
My lady, I asked a specific question. We want to know in which case file in the portal, because that's the submission my colleague has made, there's this internal memo. First, I want to know the internal memos are normally in the portal. I'll be glad to learn. But more importantly, in which case file is this internal memo so that we can authenticate? That's simple. My colleague Dan will say it is in the portal. He has a duty to furnish us with the particulars.
We have indicated, my lords, that it is in the physical file. My life friend Mr. Nyamodi will specifically address it so that I can proceed.
Your Lordship, would you kindly give us a ruling on our objection?
Please, the applicants, when you are submitting, the respondents gave you time. Please just give them time to make their submissions. You are going to respond. There will be time for you to make a recommendation.
My lord, the proceedings before you are in the public interest. They are in the public interest, and therefore the question of time management, my lords, and the need for expeditious disposal of the application before you cannot be overstated. My lords and your lordships, time and again, my friends have submitted that whereas this court can sit at odd hours where it receives an application, that in matters as mundane as the current matter before you, that this court should have had this matter in the course of the day. Because no doubt, my lord, this court has moved to the electronic age where matters are transmitted through mail and through other forms. My lord, but most fundamentally, we are here to challenge ex parte orders, not inter parte orders, not orders given inter partes. And my friends therefore cannot speak from both sides of the mouth that where you are dealing with matters of the impeachment of the deputy president, such as this, that ex parte orders cannot be issued, yet they obtained ex parte orders that necessitated the filing of the application before you. My lord, what we're dealing with here is a removal under Article 145, and which the law defines as final under Article 145(7) of the Constitution. When therefore my friends submit about the office of the Deputy President, they seem to forget that Article 145(7) refers to the finality of the Act of Senate. And therefore, all the orders obtained under the subject, all the orders obtained under the subject of this proceeding were obtained after the impeachment proceedings, after the act of impeachment. And it is therefore important, my lord, in the interest of all of us, that these matters are resolved expeditiously and timelessly, so that this court can move to the next phase. The next phase, my Lord, would be dealing with the question of the next step. My Lords and Your Lordships, it is clear that my friends do not want to proceed with that phase. And that is, we have all these multiple applications and the inability of the applicants to want to be confined to the question of time. They want to speak throughout the night. On our part, we want to sanitize this proceeding, my Lord, and stick to the point that the application does not meet the threshold set out for recusal, because recusal is also a prayer. They have advanced no reason at all to want this court to recuse itself or to find that it was not empaneled in line with Article 161, 163, 52A of the Judicial Act. We opine, my lords, that this bench was properly constituted by the Deputy Chief Justice, exercising powers donated to her by the Chief Justice, unless they're saying that there's another Chief Justice. Thank you.